A doctor sworn to do no harm, now accused of unthinkable crimes. Dr. Richard Jordan, a trusted and respected doctor in North Carolina, is at the center of a criminal investigation that cost him his job and his medical license. Authorities are accusing him of planting a hidden camera in the bathroom of a family member's home, and that's just the beginning. Jordan is also facing a second-degree sexual exploitation of a minor charge, a felony tied to child pornography. I'm Kennedi Walker, and I'll walk you through what investigators say they found and the charges that now threaten to take away the doctor's freedom. For this story, we go to both Alexander and Iredell counties in North Carolina, where a doctor is now accused of violating more than just the law, but the very oath of do no harm. Dr. Richard Dean Jordan was no stranger to respect. He practiced medicine and wore the white coat. He was a husband, a father, and now an inmate at the Alexander County Jail. According to documents obtained by WGHP, the first sign something was potentially wrong came through a cyber tip. It was sent to local authorities by the Internet Crimes Against Children Task Force, a nationwide network that investigates online crimes targeting minors. We don't know the exact specifics of the tip, but we know the tip led them straight to Jordan. He was arrested and charged with 4 counts of second-degree exploitation of a minor. The sheriff's office says the charge stems from either downloading or creating child pornography, but the allegations do not stop there. Just days after his arrest, Jordan was hit with a second wave of accusations, this time in a neighboring county. On April 7th, the investigation took another turn. The Alexander County Sheriff's Office contacted officials in neighboring Iredell County about Dr. Jordan's investigation and alleged Jordan committed crimes there as well. Major Troy Miller with the Iredell County Sheriff's Office told WGHP that Jordan had reportedly set up hidden cameras in a home he didn't even live in. The location? The bathroom. Detectives say they found video cameras Jordan allegedly placed inside a family member's bathroom, capturing people who had no idea they were being watched. And it reportedly was not just a one-time incident. According to Major Miller, the evidence suggests Dr. Jordan had allegedly been secretly recording for months. He was charged again, this time by the Iredell County Sheriff's Office, on 7 counts of felony secret peeping. Jordan was already behind bars in Alexander County, so deputies served him with the new warrants while he was still in custody. Then came more. Alexander County hit him with 1 count of first-degree sexual exploitation of a minor and 1 count of indecent liberties with a minor. A doctor once trusted to take care of others, now facing more than a dozen felony charges related to sex crimes. Jordan became licensed as a medical doctor in December of 2023. He also had admitting privileges at Wake Forest Baptist Medical Center. Now, that white coat is gone, along with the license that came with it. Just 1 week after his initial arrest, Dr. Richard Jordan voluntarily surrendered his medical license. The Wake Forest University School of Medicine released this statement. The charges are of deep concern, and we are cooperating with law enforcement in their investigation. Once we were notified by law enforcement, we took immediate action to place him on administrative leave per our policies. At this time, we had no reason to believe any of the alleged activities occurred in any of our facilities. We are unable to comment further due to the ongoing investigation. Now, years of medical training and a promising career eclipsed by disturbing allegations. Jordan's bond now totals $595,000. And joining me to talk more about this is legal expert Jason St. Aubin. Jason, thank you so much for coming on today. Let's just jump right in. When someone surrenders their medical license before trial, what does that signal legally or strategically?
Well, thanks for having me, Kennedy. I would say that if somebody has a professional license, there might be tactical reasons why they may want to go ahead and consider surrendering that license. It may be that they have a teaching license, and if they're charged with any offenses against children, they're not going to want to be in a position where they're going to want to be seen as violating conditions of their release by continuing to be close to children if they are released from custody. But I think the most tactical reason would be that in a lot of these types of situations, there are collateral issues that occur with a license, such as a review or a disciplinary proceeding. And those proceedings are civil. So you can be subpoenaed to those proceedings. People charged with crimes could face the idea that they'd have to testify about some of these matters or put anything on the record about them. So it's very important in a lot of these cases to consider just surrendering that license so you don't have to go forward and potentially interfere with any sort of criminal charges that are pending.
But when someone surrenders it, it's not like they could get it back, right? Or can they?
So if somebody surrenders their license and voluntarily decides that they no longer want to renew it, there are processes for any profession, lawyers, doctors, for terminating their license altogether. They can temporarily turn in their license pending review, or say to a review board or to a committee that oversees these things, such as the North Carolina Medical Review Board, that they will be content with not disputing any issues and therefore turning in their license. So it may be that it's just easier, instead of having that negotiation, to simply turn in and terminate the license.
Could voluntarily surrendering a license be seen as an admission of guilt in court?
Not at all. It is an act that anyone can take voluntarily, and in fact, it's honestly being used to protect somebody's right against self-incrimination, which we all have. And so it's definitely something that the prosecutor couldn't mention in a case like this.
So let's talk more about the alleged crimes. Does the fact that these alleged crimes span two counties complicate prosecution?
Honestly, not really in most circumstances. So I have the privilege of having handled numerous multi-county offenses. I actually practice in 20 different counties in North Carolina right now. And
Oh,
several of the
wow.
cases that I have, they span a few different counties. People move, children live in different places, adults live in different places. So it tends to be that it is not very common, but it is fairly common that this type of situation can occur. In this particular situation, it has really no bearing on it because North Carolina is kind of segmented into what they call prosecutorial districts. It's not a very fancy term, but it can mean that some of these prosecutorial districts have multiple counties. So one of those districts includes both Alexander and Iredell. I know and have actually taught students that went on to become prosecutors in those counties. And they will be able to move from Alexander to Iredell freely in order to prosecute different charges. They'll have access to the same files. However, if it was in a different prosecutorial district, those two would still coordinate, but technically one would usually take the lead. The defense would probably have more communication with that county.
How do prosecutors typically approach multi-jurisdiction sex crimes cases like this?
And that kind of dovetails into what I was just saying with regards to usually most of the acts or most of the accusations or the more serious accusations will have occurred in one particular jurisdiction. So the others they're not going to give up their claims, but they are going to let that other jurisdiction take the lead. Prosecutors are very busy people. They have so much to do, limited time, limited resources. They do the best job they can with the time that they have. And if they can kind of tag team a case where one prosecutor kind of waits on the other one to do most of the negotiating and discussions, then they can usually manage to resolve the cases easier that way. It becomes much more difficult when everybody wants a piece of that pie. So I think they've learned to cooperate, and they're all having the same goal to prosecute. So it usually works out quite fine.
And I know, every case is different, but do cases like this typically lead to federal charges? Could that happen here?
So I will tell you what, Kennedy, this is what's so interesting about this case. I think what you just said strikes to the heart of it. So I've represented people charged with each one of these separate kinds of conduct. I've represented a plethora of purported people who are secret peepers. I've represented quite a few people who are accused of possessing child sexual abuse material. I've even represented people accused of creating that material and engaging in some contact sexual offense with a minor. They're all difficult cases. They all involve so many fraud issues, so many complications, and they are so delicate. But what I would say regarding your question is that very few people are charged with all three of those things at once. It would seem to me that this Google account that is the source of this information, according to the articles and court information that has been obtained, that Google account contained numerous types of material in the form of pictures that depicted minors in sexual activity, which is a sexual exploitation charge, but also it included a alleged actual interaction of the defendant who is charged with a really minor child, a very young child. And that interaction could form the basis of federal charges. The federal government has shown an interest if actual material is being created in going forward and prosecuting those cases. And I've handled those cases in the past. It is not an automatic that the federal government would get involved. They look at everything on a case-by-case basis.
But we're saying that there's potentially a strong argument that there could be federal charges here with all
So there
the,
are
alleged evidence.
Yes, Kennedy, there definitely is a possibility given anytime somebody creates material that could involve any sort of sexual activity with a minor, that could be federally prosecuted. And the penalties for federal prosecution for those matters involve really heavy mandatory sentences.
In a case involving both child pornography and secret peeping, what charges typically carry more weight?
So that's a really good question because it's almost like a bingo card. We have all of the different spaces on our card when it comes to the types of offenses you might expect to see in this area of cases. So we have a set of cases involving potential contact. We have a set of cases involving consumption of material, and we have a set of cases involving placing devices in someone else's home and an invasion of privacy. So the law looks at each of those cases differently. The first degree sexual exploitation of a minor, the creation of material, that is an automatic and mandatory sentence of imprisonment in North Carolina. And again, it could go federal. So that's going to be the focal point of most of the work that's done, is to determine who that child might be, whether this is actual sexual activity depicted, and who created it. And then the other charges are also serious. Somebody's privacy and home was invaded, but they are honestly the lower level felonies when it comes to felonies. Actually, secret peeping can be a misdemeanor if somebody just looks in a window with their hands, but it becomes a felony when they plant a camera and invade someone's privacy on a continuing basis, which is what this is. So all of these cases are serious. I don't think there's a single one that a prosecutor is going to say, this is not something we would take seriously.
Absolutely. And if convicted, can you explain how sentencing is determined when multiple sexual exploitation charges are involved?
Sure. So in North Carolina, we have different degrees of this crime. For possessing the items, for distributing or duplicating the items being a degree higher, and then finally for creation. So all of those degrees, every single one, involves registering as a sex offender on the sex offender registry for a period of 30 years. They are never expungible felonies. They will always be there. And they can involve imprisonment even for first-time offenders, with first degree being mandatory imprisonment for a period of no less than 3 to 4 years, and it could be up to 6 or 7 for a first-time offender. So it's something that, those are the type of penalties that these folks are working with when they're looking at these charges. Probation is on the table if certain charges are reduced or dismissed, but in a case like this where somebody is a professional taking advantage of people's trust, it may be, that's a kind of a hard ask sometimes.
And can you explain the legal difference between indecent liberties with a minor and sexual exploitation?
So in North Carolina, we have non-contact sexual offenses and contact sexual offenses. As distasteful as this topic is to talk about in depth, as tough as it is for people to even hear about children being harmed or abused, there are subcategories of how the law treats these types of activities. For instance, first-degree sexual exploitation of a minor involves the creation of any material, images, video, anything that involves sexual activity or conduct with a minor child, somebody under the age of 16, honestly under the age of 18. So the consent laws in North Carolina for 16, but the dissemination and material are for people under the age of 18. So that particular offense, though, it can involve activity that isn't necessarily, that sexual in nature. It could be, something that is much less sexual in nature, just a physical touching rather than what we would consider to be graphic and awful. If it's just that, that's indecent liberties with a minor. It is a general catch-all crime in North Carolina, and it can catch basically anything from a statement made to somebody who is under the age of 16, to a gesture made to them, to a touch, to a kiss, to things more serious than that. So it encompasses all activity that goes towards a child, or that is even non-contact from the adult to the child, a letter, an email, that type of thing, a solicitation on a social media account. So that's how broad that charge is. It's not considered to be one of the most serious sexual offenses in North Carolina. That would be the difference between those charges.
And let's just talk more about that alleged hidden camera. Can metadata from the hidden camera footage prove who placed it?
There are lots of ways to use technology to prove who placed that camera. I think that in this case, what the evidence seems to have unearthed is that this doctor, while he might have had a medical license and may have had some medical knowledge, certainly forensically, it seems like he might be in a heap of trouble if the evidence is what it's alleged to be. The evidence seems to be that once they received a cyber tip, which is very common, these files are flagged and they are poured over by law enforcement the world over. There are these tips that come in and they investigate. They dug up and unearthed that there was a Google account attached to this email. And once they looked at the Google account, they found files that were very disturbing to law enforcement. And those files also included files from that camera. So I think in this case, the law enforcement, if that's true, might have a very easy sell to say that that camera was somehow connected to the defendant. But if there was no ability to find those files, yes, it would be much harder to trace where the camera was uploading its footage to. Normally, in a case where there is a camera that's been placed, they are able to press charges because they're able to determine who exactly is accessing that camera by the files that it's created, or the camera's found, and then the only people who could have access to that home are then interviewed, or forensic work is done to figure that out. So I don't necessarily know if metadata is necessary with a case where the footage clearly seems to be in possession of the accused, but in other cases, it may require a lot of forensic work to get to the truth.
Yeah, and you kind of basically just answered my next question. I was just trying to figure out if there is any way for the defense to argue that maybe someone else could have planted the cameras or even downloaded the material.
Well, there's a lot of ways to still argue things, and there are crazier things that I've seen happen in my career than someone else having access to accounts or using someone else's accounts to do things. I have seen, and I'm not kidding, I have seen people use their parents' phones to solicit minors. I have seen people hide their activity in numerous and various ways. While I'm not saying that occurred here, I am saying that just because there are files found in somebody's account, it doesn't mean that that person made the account, had access to the account. It doesn't mean particularly that it's even potentially their account. I've had cases where the accounts had a selfie of the person writing the account. That makes things a little difficult. But if it is something where it's just an account with files, if there are other people at that IP address that may be of interest, if there's other people who have access to that account or computer, those are always things that you still have to look for. I know in these cases, because my family and friends, when they hear that I defend some of these cases, they even scratch their chin and go, I know that it's tempting just to say because somebody had an account that's associated with them, then it must be open and shut. But there are situations, where things can go sideways. And that's why it has to be a thorough investigation always.
Is there some kind of chain of custody that has to be preserved for that digital footage to hold up in court?
That's a great question. I've actually had judges ask me about this type of evidence and how reliable and admissible it is. And so because of that, I actually started teaching other lawyers in the Charlotte area on how to get this type of evidence admitted into court. So I'm really glad that you asked me this question. It's three kind of criteria to get a video like this into evidence. So the number one criterion, the overarching principle of this type of evidence would be, is it reliable? Is it what it purports to be? And if the court in its heart of hearts and mind of minds can say, this video looks like what it's supposed to be, and it's identifiable as what it's supposed to be, then it can be admitted even over a ton of technical issues. So technical issues are going to be things like whether that recording device was functioning properly and whether it was capturing things that it needs to capture, whether it's a doorbell camera that you installed on your front porch, whether it's a nanny cam that's hidden in a room to make sure everything's okay with the kids, whether it's the dog camera that feeds your dogs and captured something that's of value. It has to capture what it's purporting to get. So that involves a witness who will testify that, yes, that's my bathroom. That's allegedly where this camera was placed. That witness may testify, yes, I was in that bathroom. That is me. And none of that activity seems to be altered or out of the ordinary. It would not even necessarily require anyone else to testify to the veracity of that footage. Then the burden kind of starts to shift to show that there might have been some tampering or alteration. If somebody's able to say that footage appears to be of me brushing my teeth in my bathroom during the day, it doesn't appear to be altered, then that would probably go to show that it is what it purports to be. Any discussion or dialogue about it being edited or something being put in there, that would go likely to what we would call the weight of the evidence rather than the admissibility. How much a jury should think about it or look at it, or what should they really feel about that evidence. And likely if they can't prove it was altered in any way or changed, it's the jury's likely to take that at face value. So it's easier than people think to get this evidence in, but you do need to cover some bases for what we call foundation. So the judge says, yeah, I'm cool with that, and doesn't sustain an objection to keep it out.
And let's talk more about the alleged victims. Can the alleged victims filmed without consent sue separately in civil court? And how often does that happen?
Oh, they absolutely can sue. So while I handle criminal cases, I'm very familiar with civil law, and I've worked in civil litigation, education seminars. I definitely know that with regards to civil lawsuits that can be pressed, invasion of privacy is definitely a tort. And that's the kind of tort, and just for the listeners, tort is a really fancy word that just means a way to sue in civil court. And a tortfeasor is somebody who is pressing that tort. So if somebody sues in civil court, they could sue for assault. They could sue for, if somebody is touched inappropriately, they could sue for assault. They could sue for emotional distress if there's fallout from abuse or from the cameras that were installed in their home. They could even, sue for the fact that the cameras were even there. So there are methods of civil recourse. They do have actual damages that can be calculated. These are things that are material, even though they're psychological. So yes, that's definitely an option for these folks.
And before I let you go, if you were the defendant's defense attorney, how would you, argue this case?
So what I'd have to start with is, in every case where people are accused of this activity, what is absolutely essential to begin with, in my opinion, is to get them to somebody who is a professional, somebody who is a psychologist, somebody who is a board certified sexologist, somebody who can run a battery of tests on that person to determine what is causing this behavior, if it is existing. What is some answers to how it can be treated? How can that person ever rejoin society in a meaningful way? And what methods are there to show or convey to a court, if this does need to be resolved in the future with a plea, how that person will not present a danger to society, or what steps need to be taken in addition to registration as a sex offender, which curtails and stops them from traveling to certain places or doing certain things, what additional steps would the court need to feel comfortable that that person could ever rejoin society in a meaningful way? That's honestly the first step, because to start with the idea that, all of this evidence is not going to be worthwhile or will be thrown out, it's more difficult position. If this evidence is found, it likely will lead to charges, and it is a very sticky situation to then try to argue, that it doesn't exist, or that somebody planted it, or that it's not what it purports to be. The better strategy that I have found in my career is first to make sure that the police followed proper protocol, because sadly, people may not agree with this, but the Fourth Amendment honestly protects everyone against searches and seizures. It protects somebody who has their house and door kicked in by the police and flashbangs thrown in for no reason. It protects people who are just sitting in their house and the police want to come in and search through their stuff and find nothing. But why we hear about it is it also protects that person that had a bag of drugs in their car. It protects that person who had a gun underneath their seat. It protects somebody who may have even killed someone when their property is searched illegally and a body is found. It protects also folks that are accused of these kind of offenses. It is rare that a court would throw out alleged child sex material and uphold someone's rights in regards to it, but it can happen. So the number one thing is to look at how that material was seized, how it was collected and gathered, and then after that to make determinations of the client's knowledge or ability to know whether that material was sexual in nature, whether that material was knowingly gathered by them and they were aware that they had it. So there are levels of defense, but to be completely frank, the best way to approach, I think, these situations is that to remember that even though it is easy to think of the folks that are charged with this as people that we can never associate with, you never know when it might be a colleague or somebody in the community that you're aware of that is charged with this. And the end goal of the system, unfortunately, some people may say that we should lock those folks up forever. But the idea here is that they have to rejoin society at some point, and we need to make sure that society is safe. So to do that, they need access to the best help and care available, and they need to stick to that care and health so that way they can continue to be productive people. So that's a long answer, but it's definitely a really important topic.
Absolutely, so important. And this is something that we will be continuing to follow here at Law&Crime. Jason, thank you so much for coming on today.
I'm so glad to be back, Kennedy. So nice to meet you.
The Alexander County Sheriff told WGHP detectives are still searching Jordan's devices, and there could be more charges. For Law&Crime, I'm Kennedi Walker.